The court today decides to save a statute Congress did not write. The court regards its strained statutory interpretation as judicial modesty. It is not. It amounts instead to a vast judicial overreaching. It creates a debilitated, inoperable version of healthcare regulation that Congress did not enact and that the public does not expect. The court's disposition, invented and atextual as it is, does not even have the merit of avoiding constitutional difficulties. It creates them. The holding that the individual mandate is a tax raises a difficult constitutional question. The Constitution, though it dates from the founding of the Republic, has powerful meaning and vital relevance to our own times. The constitutional protections that this case involves are protections of structure. Structural protections, notably the restraints imposed by federalism and separation of powers, are less romantic and have less obvious a connection to personal freedom than the provisions of the Bill of Rights of the Civil War amendments. Hence, they tend to be undervalued or even forgotten by our citizens. It should be the responsibility of the court to teach otherwise, to remind our people that the framers considered structural protections of freedom the most important ones, for which reason they alone were embodied in the original Constitution and not left to later amendment. The fragmentation of power produced by the structure of our government is central to liberty, and when we destroy it, we place liberty at peril. Today's decision should have vindicated, should have taught this truth. Instead, our judgment today has disregarded it. For the reasons here stated, we would find the act invalid in its entirety. We respectfully dissent. That is the dissent of Scalia, Kennedy, Alito, and Thomas. So you not only have a 5-4 ruling, you have a 5-4 ruling in which the minority dissenters are unusually harsh and dismissive of what they believe is, using their own words, an attack on liberty. This is powerful stuff here.